Hi, good morning. This is Attorney Davis with Davis Legal Center. So, you know what? Something just hit me like a ton of bricks today. We've been sharing and we've been meeting every week for Tip Tuesday, and I've never made a video about what happens when you get arrested in federal court, just at a basic level. What happens? So, usually, friends, the federal government is way more organized than state or local police will ever be. Okay. And the way that I usually see the marshals secure an arrest is after they have conducted very thorough investigations into a person's criminal history. You've been surveilled, they have pictures, they have wiretaps, they have all kinds of stuff. So the federal government tends to have way more resources than state and local police, as a just putting that out there. And so, usually, depending upon who the arrested individual is, and usually what the person's arrest or history is, the marshals will either, depending upon who the person is, the marshals will either call that person up or go get that person. And usually, they make that determination based upon someone's risk to flee. So they try to make a determination as to whether or not they view the person to be violent or uncooperative, and just different things like that. So once an arrest is made, whether it be by the person voluntarily surrendering themselves either to the court or to the marshal's office, or if the marshals actually go and pick that person up, the suspect up, the person will then appear for what we call magistrate court or initial appearance. Only thing that's going to be determined at initial appearance is what the bond conditions are, and usually an indictment has already been secured at the time of the initial appearance, which is a lot different from state court. And so what a lot of the general public just does not know or is not familiar with is that we are familiar with juries meeting for purposes of trial. Well, in federal court, and also in state court too, but it's very rare, there are grand juries that preside where the defense and the defendant will never be present or privy to. This is something that the government puts on to try to secure charges and just make a determination as to what charges they will move forward on, which is a lot different from how state court investigations are done. Okay. So going back to my initial discussion, the bond hearing or magistrate court appearance in federal court usually serves the function of determining whether or not someone has the ability to pay, whether or not they can afford a private attorney. Thank you, Sixth Amendment, because the Sixth Amendment protects those that cannot afford counsel, and the court will appoint counsel because you are entitled, according to the Sixth Amendment, you're entitled to counsel if you are facing incarceration. The court will do that. The court will also determine what the bond conditions are. Usually the government and the defense have already had this conversation and either have come to agreement or not, and the court will entertain argument and note the objections for the record if there are any. After that is done, and depending upon whether or not the person will be detained, there will be a detention hearing that will be set at a future date, or in the alternative, the bond conditions, pre-trial release conditions are set. The person is then arraigned, or the government is announcing for purposes of the record what charges it is going forward on. The charges that the grand jury found, that is what's listed in the indictment. The defense will have an opportunity to enter in a plea, and that's always not guilty. Okay, so I hope that you enjoyed this week's Tip Tuesday. Have a great week, everybody. Bye.